mattress sutures, ruptured intervertebral disc, endometrial biopsy curette, cervical cesarean section, systolic ejection murmur, superficial femoral arteries, acute inflammatory abscess, total cardiopulmonary bypass, general inhalation anesthesia, lateral subtrochanteric incision, chronic coronary insufficiency, computerized axial tomography. Ladies and gentlemen, the court instructs the jury that the jury has no right to disregard the testimony of the defendant on the grounds that he is a defendant and stands charged with the commission of a crime. The law presumes the defendant to be innocent until he is proved guilty, and the law allows him to testify in his own behalf. The jury should fairly and impartially consider his testimony together with all the other evidence in the case, and if from all the evidence the jury have any reasonable doubt that the defendant committed the robbery, they should give the defendant the benefit of the doubt and acquit him. The court instructs the jury in the language of the statute that no person shall be disqualified as a witness in any criminal case by reason of his having been convicted of a crime, but such conviction may be shown for the purpose of affecting his credibility. The court instructs the jury in the language of the statute that robbery is the felonious and violent taking of money, goods, or other valuable thing from the person of another by force or intimidation. The court instructs the jury that armed robbery is robbery while armed with a dangerous weapon. The court instructs the jury that in order to justify a conviction, the evidence must not only be consistent with the guilt of the defendant, but it must also be inconsistent with his innocence. If the evidence is equally consistent with guilt and innocence, the defendant is entitled to the presumption of innocence, and the verdict must be not guilty. Let's try that one again. Ladies and gentlemen, the court instructs the jury that the jury has no right to disregard the testimony of the defendant on the grounds that he is a defendant and stands charged with the commission of a crime. The law presumes the defendant to be innocent until he is proved guilty, and the law allows him to testify in his own behalf. The jury should fairly and impartially consider his testimony, together with all the other evidence in the case, and if from all the evidence the jury have any reasonable doubt that the defendant committed the robbery, they should give the defendant the benefit of the doubt and acquit him. The court instructs the jury in the language of the statute that no person shall be disqualified as a witness in any criminal case by reason of his having been convicted of any crime, but such conviction may be shown for the purpose of affecting his credibility. The court instructs the jury in the language of the statute that robbery is the felonious and violent taking of money, goods, or other valuable thing from the person of another by force or intimidation. The court instructs the jury that armed robbery is robbery while armed with a dangerous weapon. The court instructs the jury that in order to justify a conviction, the evidence must not only be consistent with the guilt of the defendant, but it must also be inconsistent with his innocence. If the evidence is equally consistent with guilt and innocence, the defendant is entitled to the presumption of innocence, and the verdict must be not guilty. Ladies and gentlemen, the court instructs the jury that the jury has no right to disregard the testimony of the defendant on the grounds that he is a defendant and stands charged with the commission of a crime. The law presumes the defendant to be innocent until he is proved guilty, and the law allows him to testify in his own behalf. The jury should fairly and impartially consider his testimony, together with all the other evidence in the case, and if, from all the evidence, the jury have any reasonable doubt that the defendant committed the robbery, they should give the defendant the benefit of the doubt and acquit him. The court instructs the jury in the language of the statute that no person shall be disqualified as a witness in any criminal case by reason of his having been convicted of any crime, but such convictions may be shown for the purpose of affecting his credibility. The court instructs the jury in the language of the statute that robbery is the felonious taking of money, goods, or other valuable thing from the person of another by force or intimidation. The court instructs the jury that armed robbery is robbery while armed with a dangerous weapon. The court instructs the jury that in order to justify a conviction, the evidence must not only be consistent with the guilt of the defendant, but it must also be inconsistent with his innocence. If the evidence is equally consistent with guilt and innocence, the defendant is entitled to the presumption of innocence, and the verdict must be not guilty. Gentlemen of the jury, any owner of a naturally dangerous animal is liable for damages caused by such animal biting a person, whether the victim is in a public place or is lawfully on the private property of the owner of such animal. Any person who is unlawfully on the premises or property and is bitten or molested in any way by an animal known to be dangerous would have a cause for action. Now, a naturally dangerous animal such as a wolf, tiger, or leopard is regarded in a different light than a domesticated animal such as a dog, cat, or horse, although these animals can, on occasion, certainly be just as dangerous, but as a general rule, a domesticated animal tends to be tame and would not fit into a category of a naturally dangerous animal. Now, usually any owner of an animal who is of a species that is dangerous by nature, the liability of the keeper of that animal is absolute, and the plaintiff is not required to give or produce proof of the knowledge of that animal's propensities. Now, the word propensity, as used in this charge, means a particular disposition of mind or character. Proof is not required that the plaintiff at the time of the mishap knew of that particular animal's disposition. Furthermore, it is not required that the plaintiff try to prove that the defendant was negligent in the manner in which he kept this animal. Remember that the liability of the owner of a dangerous species is absolute. Now, we do approach another area in which if a person invites an attack by an animal, or if that person assumes all risk of such animal, and that person is attacked and injured, the owner of that animal would not be held liable for any injuries or for any consequences. Please remember that if you decide for the plaintiff, defendant must have voluntarily invited an attack by this animal or voluntarily assumed all risk of going near that animal. Now, the word voluntarily indicates a freedom of choice. It is the option to expose oneself or not to expose oneself to such danger. Now, I caution you that in weighing all these matters, you must also take into consideration the plaintiff's age. Your consideration of this suit must involve the plaintiff's maturity, for as you realize, age does not necessarily bring maturity. Let's try that one again. Gentlemen of the jury, any owner of a naturally dangerous animal is liable for damages caused by such animal biting a person, whether the victim is in a public place or is lawfully on the private property of the owner of such animal. Any person who is unlawfully on the premises or property and is bitten or molested in any way by an animal known to be dangerous would have a cause for action. Now, a naturally dangerous animal such as a wolf, tiger, or leopard is regarded in a different light than a domesticated animal such as a dog, cat, or horse, although these animals can on occasion certainly be just as dangerous, but as a general rule, a domesticated animal tends to be tame and would not fit into the category of a naturally dangerous animal. Now, usually any owner of an animal who is of a species that is dangerous by nature, the liability of the keeper of that animal is absolute, and the plaintiff is not required to give or produce proof of the knowledge of that animal's propensities. Now, the word propensity, as used in this charge, means a particular disposition of mind or character. Proof is not required that the plaintiff at the time of the mishap knew of that particular animal's disposition. Furthermore, it is not required that the plaintiff try to prove that the defendant was negligent in the manner in which he kept this animal. Remember that the liability of the owner of a dangerous species is absolute. Now, we do approach another area in which if a person invites an attack by an animal, or if that person assumes all risk of such animal and that person is attacked and injured, the owner of that animal would not be held liable for any injuries or for any consequences. Please remember that if you decide for the plaintiff, defendant must have voluntarily invited an attack by this animal or voluntarily assumed all risk of going near that animal. Now, the word voluntarily indicates a freedom of choice. It is the option to expose oneself or not to expose oneself to such danger. Now, I caution you that in weighing all these matters, you must also take into consideration the plaintiff's age. Your consideration of this suit must involve the plaintiff's maturity, for as you realize, age does not necessarily bring maturity. $3,634,234. $4,604,075. $6,204,903. $1,093,015. $6,434,034. $8,347,396. $2,342,606. $7,252,513. $9,192,233. $3,342,644. $343,525,323. $243,426,105. $954,205,015. $134,434,093. $864,324,435. $206,183,704. $975,252,633. These are times. 9:32, 10:13, 5:30, 6:57, 1:21, 5:52, 9:20, 1:07, 5:15, 9:36, 10:41, 12:44, 7:30, 8:30, 2:24, 6:30, 10:40, 2:09, 6:08, 10:45, 11:54, 3:15, 11:15, 10:10, 3:37, 7:15, 11:55, 3:02, 7:11, 11:57, 1:12, 4:54, 12:21, 3:21, 4:49, 8:45, 12:16, 4:01, 8:24, 12:13. Okay, these are dates. January 1, 1992. February 14, 1994. March 3, 1963. April 14, 1991. May 5, 1996. June 8, 1993. July 4, 1960. August 3, 1997. September 24, 1990. October 31, 1999. November 29, 1986. December 31, 1954. January 6, 1996. February 28, 1990, March 16, 1974, April 7, 1992, May 24, 1995, August 27, 1954, September 9, 1996, October 13, 1974, November 15, 1999, December 26, 1995, January 18, 1999, February 8, 1989, March 26, 1998, April 23, 1998, June 18, 1978, July 23, 1997, August 9, 1943, September 30, 2005, October 12, 2004, November 27, 2001, and December 6, 2006. Okay, Social Security numbers. 364-34-8645. 375-960934. 167-57-6432. 342-75-9840. 753-691943. 934-122235. 834-146842. 643-121296. 374-236846. 274-742856. 546-873158. 953-952396. 874-16-1238. 934-920434. 012-84-2736. Okay, this is descriptions, and I'll read the whole thing, and then I'll wait for you to catch up. 2-story, 3-bedroom, 2-car cement block garage, basement, $95,000. Call 232-434-5525. Prime location, 2.9 acres, $175,000, 7 acres, $365,000. Call 436-643-2976. Three-bedroom, 1-bath, $850, Section 8 welcome, 343-232-1231. Three-quarter bedroom, $1,300, renovated, Section 8, 2-car garage, $950. Large kitchen, 15 by 16, 4 bedrooms, 14 by 14, 2.5 baths, 3-car garage, C at 384 West Saybrook, Manito, 432-243-1235. Question by defense attorney. Ready? And some of the television clips actually named specific people who might have associated with Mr. Menendez, who might have organized crime. Ties, correct, isn't that right? Right. And one of those people was Noel Bloom, was he not, to the best of your recollection? Right, that's correct. Let me ask you this. Going back to the incident that occurred in New Jersey with Eric Menendez, when Mr. Menendez came running on the court, what was Eric Menendez's response at that time? Objection, irrelevant, overruled. You can answer that question. He was embarrassed by it. Was he upset? Embarrassed, upset, yes. Did he indicate to you that he should follow his father's instructions and make it hard for him to hit the lobs? Yeah. Well, objection calls for hearsay, overruled. You can answer the question. After Mr. Menendez walked off the court, Eric looked at me and said, objection to anything he'd say as hearsay, overruled. Go ahead. He said to me, my dad is not going to be happy until I'm diving all over the tennis court. So I just started feeding him balls basically all over the place until he dropped. Until Eric dropped? Right, until he basically couldn't go on. Now that was contrary to what you felt was the appropriate way to teach, is that right? Yes. When you first contacted the Menendez family here in Los Angeles, was that when they lived in Calabasas? Yes. Did you ever go to the Calabasas house? Once. And do you remember that house as being filled with boxes that had not been unpacked? Objection, irrelevant, outside the scope of direct, overruled. Yes, that's correct. There were boxes, I believe, inside the kitchen and on the floor. And that was a rental house to the best of your knowledge? Yes. And you also indicated that you socialized with Lyle Menendez in California, and periodically, did you also socialize with Eric? Occasionally. And was that generally in connection with Lyle as well? Yes. And that's because of your age similarity and your friendship with Lyle? With Lyle, right. And you had dinner occasionally at the Menendez family home. Is that right? Yes. Tell us about this dinner that you had at their home. Did they seem to you to be normal family dinners? Objection, irrelevant, overruled. You can answer the question. Wouldn't really consider them normal. Mr. Menendez would basically kind of control the conversation, discussions. He would basically ask questions. You would respond with an answer. If he felt it deserved a follow-up question, he would ask the question. You'd respond again. Most of the questions he would ask, at least me, would be regarding work and my family. My family at the time was living back in New Jersey. He would ask how they were, and then he would just again ask questions about work, basically. All right. And what about the Menendez brothers? What was their part in these conversations? They really didn't speak very much unless, again, Mr. Menendez would ask a question. It wasn't a very relaxing environment. It was very formal, would you say? Very formal. And serious? Yes. And when Eric and Lyle Menendez were just around you, not around their partners, were they different? Did they act differently? Yes, they did. Much more relaxed. We joke around, a lot more easier going. And what about Ms. Menendez at these dinner sessions? Did she say anything? Did she ask any questions or answer questions? She would answer questions. I mean, she would ask how was dinner, or if I wanted seconds or something else to drink, whatever. But again, I would say Mr. Menendez controlled the conversation during dinner. She did not control it. She went along with what he wanted to talk about? Right, that's correct. You also indicated that Mr. Menendez expressed a disapproval of Lyle's girlfriend, Christy. Is that right? Yes. And Lyle broke up with her because of Mr. Menendez's disapproval. Is that right? Yes. And you said Lyle was upset about that? Yes. Was he sad? Yeah, I'd say sad, yes. And Christy wasn't the only girlfriend of Lyle's that Mr. Menendez disapproved of, was she? That's correct. You mentioned, I think, Jamie Pisarcik also was another girlfriend of Lyle's. Is that right? That's correct. And Mr. Menendez disapproved of her as well. Is that correct? Yes. And did Mr. Menendez express that disapproval in your presence periodically? Mr. Menendez? Did Mr. Menendez? Yes. Oh, no, I don't think so. Did Mr. Menendez indicate that he thought that Lyle's girlfriends were too old? He mentioned that about Christy, but I don't recall that regarding Jamie. Okay. You never heard him make similar comments about Jamie as he made about Christy being too old? That's correct, I don't. Yes, that's correct. What about Jamie being a gold digger? Did you ever hear him make that kind of a comment about Jamie? Yes? No. If I read to you your testimony at the previous trial, would that refresh your recollection regarding comments that Mr. Menendez might have made about Jamie as well as Christy? I believe it was Christy that that comment was made towards. The gold digger comment, yes. So he thought Christy was a gold digger and too old, correct? Right. But you don't remember, as you sit here today, him making the same type of comment about Jamie, is that right? Yes. And again, if I read to you from your testimony at the previous trial, do you think that might refresh your recollection? It might. Let's give it a shot. I would object to reading aloud anything that refreshes his recollection and ask the witness be allowed to read it privately. First, identify what it is by page and line. Page 7,593 of the trial transcript, lines 4 through 13. Your Honor, we'd also object that the part in question is hearsay. All right, first of all, you're offering it only to refresh the witness's recollection, correct? All right, then you may show it to him. May I show it to him or read it? Show it to him. Let's see, this is going to take a minute. I show you this portion of your testimony, Mr. Berman, just the part that's highlighted here. Would you read that to yourself? Does that, after having looked at your testimony, does that refresh your recollection about comments that Mr. Menendez made regarding Lyle's girlfriend, Jamie Pisarcik, being too old and a gold digger? Object to any question involving what Mr. Menendez said as hearsay. Overruled. Can you repeat that question? Now, the portion of your testimony that I just showed you, does that refresh your recollection about whether or not you heard Mr. Menendez make similar comments with respect to Jamie Pisarcik as he made with respect to Christy about being too old and a gold digger? Again, you know, if I said it, you know I heard it. Yes. Did you say it? Yes, I did say it. Yes. Is your recollection refreshed as you sit here today about a comment or comments Mr. Menendez made about Jamie? Again, is it refreshed? I don't know. You said it before at the previous trial, but now you don't remember specifically. Is that fair? Right, before 93. It was only 3 years prior. Now you're talking about 6 years ago, 6 years plus. So, in addition to the dinners that you attended at the Menendez home, you spent other time periodically around the family as a group. Is that a fair statement? Yes. And did you get the impression as to how Jose Menendez ran his home? Yes. And how did he run his home? I'm going to object, Your Honor, as irrelevant. Sustained. Did you get an impression as to the relationship between Jose Menendez and Eric and Lyle Menendez? Yes. And how did Jose Menendez treat Eric and Lyle Menendez? I'm going to object, Your Honor. It's irrelevant. Also calls for speculation from this witness. You're asking for a particular time frame, yes, here in Los Angeles, okay? And you're asking about generally how he treated the two defendants, yes, objection overruled. We'd object as improper opinion testimony without lacks foundation, overruled. Based upon your observations of what you saw, right, he was very firm with Lyle and Eric. I didn't really see any warmth between Mr. Menendez and his sons. And did he treat his home like a company? I'm going to object. Now that's argumentative. Well, it's ambiguous. Objection sustained. Did you testify at the previous trial? Regardless of whether he testified at some other trial that way, it still would be ambiguous. Well, Your Honor, I'm trying to refresh his recollection. I understand what you're trying to do, but it's still irrelevant too. What other impressions did you obtain from your contact with Mr. Menendez and Lyle and Eric Menendez regarding how Mr. Menendez treated his sons? He was very strict with them. I remember one evening I went over to the house. Okay, you've answered the question. You were going to tell us the basis for your feeling that he was strict with them. What happened that day when you went over to the house? I'd object as irrelevant. Sustained. What about, you mentioned that Mr. Menendez wanted Lyle to break up with Christy, and he did so, is that right? Yes. What about school? Did he make decisions for Eric or Lyle Menendez, or both regarding schools they selected? Yes, that's correct. If he did Mr. Menendez make most decisions for Eric and Lyle Menendez as best you could see from your perspective as a friend? Objection calls for speculation and hearsay. Sustained. Objection sustained. 200, 10 minutes, starts with the court. People against Flores, the defendant, his counsel, the district attorney, and the jury are all present. Shall we proceed? Do you want to make an opening statement? Yes, Your Honor, thank you. And by the way, has the information and the plea been read to the jury? Yes, Your Honor, I believe it was yesterday. Was it not, Mr. Aide? It was, Your Honor. Very well. May I proceed, Your Honor? Yes, if you will, please. Mr. Aide, would you like to make an opening statement at this time? Not at this time, Your Honor. Very well. Shall we proceed then? Thank you, Your Honor. People call Susan Miller. You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Take the stand, please. State your name, please. Susan Miller. Would you keep your voice up? Is it Mrs. or Miss Miller? So we can all hear you. We want to hear what you have to say. Susan, I am calling your attention now to the date of February 12, 1970. On that date, were you at the Gondo Apartments, which I believe are located at 5525 East Pacific Coast Highway in the city of Long Beach, County of Los Angeles? Yes. And sometime that evening, did you leave that location and by leaving go to the parking lot? Yes. Do you recall approximately, Susan, what time that was? 11 o'clock. Did you then have an automobile at the parking lot? Yes. And what type of automobile was this? A 66 green Mustang. Is the Mustang, you mean a two-door car? Yes. Now, did you then proceed directly to your vehicle? Yes. And did you get into it? Yes. Did you shut the door? Yes. Did you lock the door? No. And so you are sitting in your car with the door unlocked, is that correct? Right. Did you attempt to start the vehicle? Yes. Did anything unusual happen at that time when you attempted to start your vehicle? Yes, the defendant came from the back of the car, got in, and I turned around. At first I thought it was my boyfriend, and I looked and I realized it wasn't, and I said, just a minute, Susan. Now, you say by the defendant, are you pointing out Mr. Flores, who is seated at the end of the table? Yes. So he, you say, got into your car. Is that correct? Yes. Did he get into the front or the back seat area? He came from behind me in the back. He was in the back seat area? Yes. Were you pushed forward when he got in? Yes. Just lean forward. Now, when he got in, did he have any kind of a weapon with him that you noticed? He had a knife. Where was the knife? In his right hand. Now, you say you thought it was your boyfriend, so you looked towards him at that time. Is that correct? Right. When you recognized it was not your boyfriend, what did you do? I just said, what do you want? What did he do, if anything? Nothing. He just looked at me. Did you stay in the same position behind the wheel of the car? No. I tried to get out on the other side and start screaming. What do you mean by you tried to get out? I kept trying to open the door and he kept shutting it, and then he started hitting me. Where was the knife at this time, Susan? He had his arm around my neck and he had the knife in his hand. What hand did he have the knife in? His right hand. Was he striking you then with his left? Yes. This was while you were attempting to open, I take it, the passenger door of the car. Is that right? Yes. Now, what happened? Do you recall what happened next? I blacked out then, and when I woke up, I was laying with my head in the back seat, and my feet were in the front, and he had a knife in my stomach. Where was he at this time, Susan? He was driving. The car was moving? Yes. This is, I believe, a bucket seat type of car. The Mustang, is that right? Yes. So there is a space between the seats, not a bench seat. You were kind of draped in this area, is that right? My feet were against the air conditioner and my head was in the back. You say the defendant had a knife in your stomach at this time? Yes. He had it in his right hand, just holding it against my stomach. Did you say anything to him at that point, or did he say anything to you? When I woke up, I just introduced myself, and then, why did you introduce yourself? Because I was afraid, and I thought by talking to him and trying to find out what he wanted, maybe he wouldn't hurt me. Did he say anything to you at that time? He said that he had just escaped from prison and that he just wanted my car and my money, that he was running and he was going to Mexico. You were driving in the vehicle